CRJ 225. This is the podcast for week number 5 and number 6 for criminal law. For these 2 weeks, we look at inchoate crimes, also known as incomplete crimes. Inchoate crimes or incomplete crimes are acts taken towards committing a crime, acts that constitute indirect participation in a crime. Although these acts are not themselves crimes, they are illegal because they are conducted in furtherance of a crime, and society wishes to deter individuals from taking those kind of steps. A type of crime that is completed by taking a punishable step towards the commission of another crime would be an inchoate crime. The basic inchoate offenses are attempt, solicitation, and conspiracy. The crime allegedly intended is called the target offense. Except for conspiracy, inchoate offenses merge into the target crime. This means that if a defendant is prosecuted for the target crime, attempt and solicitation cannot be charged as well. However, both conspiracy to commit a crime and the crime itself may generally be charged. For week 5, we're going to look at solicitation and conspiracy and briefly attempt, and then week 6 we are going to focus entirely on attempt. So let's break down solicitation first. Solicitation is an inchoate crime that involves seeking out another person to engage in a criminal act. A defendant may be charged with solicitation if he or she requests or induces another person to commit an act that would amount to a felony. The 2 elements of solicitation are the intent to have someone else commit a crime and an act committed in furtherance of convincing another person to commit a crime. In order to establish the first element of solicitation, the prosecutor must show that the defendant affirmatively intended to have another commit the crime, another person commit a crime. This means that an individual may not be charged with solicitation for mistakenly asking another person to commit a crime, often because the individual does not realize the act itself is a crime. In Illinois, solicitation can be found in 720 ILCS 5/8-1, titled Solicitation and Solicitation of Murder. And that statute, which I've asked you to read, lists solicitation as having been committed when, with intent, that an offense be committed, and here we're talking about offenses other than first-degree murder, according to the statute. He or she, and these words are important, commands, encourages, or requests another to commit that offense. So the solicitation is a command, encouragement, or a request of another to commit that offense. Statute goes on to define solicitation of murder as being when a person commits the offense with the intent that the offense of first-degree murder be committed. Now, we'll cover first-degree murder later, and I don't really want you to get too hung up on murder right now, but know that these, for solicitation, or the purposes of solicitation, that we treat murder differently, or we are going to focus on murder differently. The statute goes on to lay out the sentence expectations, and a person convicted of solicitation may be fined or imprisoned, or both, not to exceed the maximum provided for the offense solicited. So in other words, the same sentence expectations as the offense for which you solicited someone else to commit the act. So serious, right? Let's move on to talk a little bit about conspiracy. Conspiracy occurs when two or more people agree to commit a crime together. Notice the difference from solicitation. Thus, conspiracy requires two or more participants. One person cannot singly conspire to commit a crime. In many states, conspiracy also requires that the individuals conspiring have carried out an obvious act in furtherance of the criminal plan. Now, unlike attempt, which we are going to talk about last in this podcast, a defendant cannot or can be charged for both conspiracy to commit a crime and the actual crime itself. These are seen as two separate offenses in criminal law. So you can be charged with both the conspiracy to commit the crime and then the act of committing the crime itself. Conspiracy crimes generally can carry a penalty on its own. In addition, conspiracies allow for derivative liability where conspirators can also be punished for the illegal acts carried out by other members of the conspiracy, even if they were not directly involved in or had no knowledge or expectation of those acts. In other words, where one or more of the members of the conspiracy commits other illegal acts to further or in the process of furthering the conspiracy goals, all members of the conspiracy may be held accountable and liable for the other criminal acts, even though they didn't conspire to commit those acts specifically. Where no one has actually committed a criminal act, the punishment varies. Some conspiracy statutes assign the same punishment for conspiracy as for the target offense, as we just discussed with solicitation. Others impose lesser penalties. Illinois is in that category, imposing lesser penalties. And the Illinois statute found at 720 ILCS 5/8-2, which I've asked you to read, provides in part, under elements of the offense, again with the intent that an offense be committed, he or she, and the exact words are, agrees with another to the commission of that offense. So there's an agreement, a meeting of the minds. They are on the same page on the terms. That section also provides that you can't be convicted of a conspiracy to commit an offense unless, and again, exact words from the statute, an act in furtherance of that agreement is alleged and proved to have been committed by him or her or by a co-conspirator. So someone had to have taken an act in furtherance. In other words, they didn't just talk about it and plan it. They took a step towards completing the act, one or the other or both of the co-conspirators, or all of the co-conspirators, or one of the co-conspirators. Under Part B, it provides that it's not a defense to conspiracy that the person or persons with whom the accused is alleged to have conspired has not been prosecuted or convicted, has been convicted of a different offense, They're not amenable to justice. They can't be brought to justice. They've been acquitted, or they lack capacity to commit an offense. So it's saying those things are not a defense. Sentencing, as you look to that section, is a sentence below the sentence that applied to the crime itself. So if the sentence for the crime conspired towards was a Class 1 felony, a conspiracy conviction would be subject to a sentence of a Class 2 felony, or as a Class 2 felony, under Illinois statute. So one classification below the actual or target act. Now let's focus for a minute on attempt crimes. To be charged with an attempt crime, a defendant must intend to commit a specific offense. They have to take an action, and the action must be a substantial step towards the commission of that offense. Most cases hinge on whether a specific action is a substantial step. And you can't see me, but I'm making those little quotation marks, as you might see me do when you have me in an actual live, in-person, or remote class. If the action was not a substantial step, there's no attempt crime. And again, substantial step is something, we know it when we see it. Not all crimes can be attempted, legally speaking. Only those crimes that have specific intent. Specific intent refers to the state of mind in which an individual plans to commit a certain crime, knowing what the outcome may be. For instance, attempted battery is not a criminal charge because the crime of battery doesn't require a premeditated intent to cause harm. But someone who threatens bodily harm may be charged with, and hopefully you're answering this in your head because it goes back to things that we've covered previously this semester, assault. One common example of an attempted crime would be attempted murder, where an individual must have the intent to kill another individual, then take action towards that end, but fall short of actually doing so. And that happens, right? It happens all the time. In order to better understand when a person may be charged with criminal attempt for a crime, it is helpful to outline the stages of crime. Generally, the stages of an incomplete crime consist of the following. 1. The perpetrator considers committing a crime. They weigh the pros and cons, whether or not to do it. They put in the thought, right? They're thinking it out, putting in the thought. But at this point, it is just a thought. Stage 2, perpetrator then affirmatively decides to commit the crime. So they've thought about it, they weighed the pros and cons, and they've made a decision. I'm going to do this, I'm going to commit the crime. Again, it's still just a thought. The next stage, the perpetrator prepares for the crime, perhaps bringing in accomplices or purchasing the material, the gun, the tools, the disguises, etc. Now we've moved from just a thought. Now we've moved to, can you say it with me? In your mind, You can say it with me. It's a substantial step. After that, the perpetrator begins the commission of the crime. They drive to the location. They enter the building. Substantial step. And then the final stage for attempts, for one reason or another, the crime isn't completed. Whatever that reason may be. And when you look at the cases, those reasons are all over the place. But clearly, there was an intent and there were steps taken, and for whatever reason, they just weren't able to finish it, to complete the act. Now, this is a very general list, and as I said, it's going to depend on the offense and the facts of the case. And that's what makes what we do so interesting, so great. Every case is different. Every set of circumstances is different. Every opportunity is different. Now, in Illinois, the statute defines attempts in Section 8-4. Same body of statutes, same area, last paragraph of that section. And again, you've hopefully read that statute before you listen to this podcast. But it provides, again, intent of a specific offense. He or she does, and the exact wording is, any act that constitutes a substantial step towards the commission of that offense. Any act. Go back to what I just discussed. So they move from the thought process to they actually prepare for by buying a gun, acquiring a gun, tools for the job, disguises, mapping out entryways, whatever, or drive to the actual location. There's a substantial step towards the commission of that offense. The statute provides also that impossibility is not a defense to a charge of attempt. Exact wording, it is not a defense to a charge of attempt that because of a misapprehension of the circumstances, it would have been impossible for the accused to commit the offense attempted. Classic case I always remember, the classic example in the many different versions of criminal law that I've taken from, the time I sat in the classes that you're taking or this class, and then onward. They make all the plans to rob the bank. They have all the tools, the weapons. They've mapped it out. They have their getaway plan. They have everything lined up, and they go to the bank, and whoops, we forgot it's Labor Day. The bank is closed. Now, the sentence: a person convicted of attempt may be fined or imprisoned or both, not to exceed the maximum for the provided offense. So for that target offense. We're going to cover attempt crimes in greater detail next week. But after you listen to this, and as you prepare for week number 5 and then complete week number 6, I hope you keep in mind your new vocabulary, the things you've learned prior to this week, and then things like this week, inchoate crimes, what that means, how these crimes, the 3 crimes are similar and related, and how they're different, and how they relate to and are often related to the crimes that we are going to start getting into in the weeks to come, the more specific types of crimes. Again, this is the podcast you'll use for weeks 5 and 6. I hope you'll listen to it again in week 6. It won't hurt you. It'll only help you. In the interim, you know where to find me. Stay well. I appreciate all your efforts in the first 4 weeks of the semester.